Good afternoon, ladies and gentlemen. Extremely sorry for this slightly strange and unforeseen circumstance where, for some reason, some of our outstation colleagues and clients could hear us while others could not. As a result of which, we had to try and restart the whole session. I know that as a result of this, some of you might have already logged off, and we much appreciate the patience for every one of you who has decided to stay on for this session. If any of your colleagues have logged off, if you would want to let them know that we are starting the session now, we will deeply appreciate that. If for any reason that is not possible today, we will understand, and we will then, on another day, hopefully do another session for those colleagues. I will assume for the moment that nobody can, that people can hear us, and I will assume that they could not hear us the first time. So we will start pretty much from scratch. What I had been saying in the first instance was that there were over 40 labor enactments, and through a series of discussions starting with 2002, a decision had been taken to consolidate all of these 40 into 4 labor codes, or one labor code with 4 parts rather. Now, this whole process is likely to still take some more time. We are currently on the first of these labor codes, which has recently received the presidential assent, and that is the code on wages. The code on wages deals with essentially 4 laws. The purpose of this whole exercise and what we are hoping will be the benefits of this will be that it will provide additional clarity on various concepts which currently have been stated differently in different laws. For example, the concepts of employment, concept of wages, when they apply. We are also hoping that this will lead to a rationalization of the number of compliances. We did some rough calculations. Since the rules are yet to be published and the law is yet to be notified, it has only received presidential assent. We are not exactly sure, but it looks like from roughly about 20 critical compliances that a company has to currently do for every state under these 4 laws put together, this will be reduced to somewhere between 4 to 6. We are still not absolutely sure what the number will be. It will depend on the final rules that come out. Another advantage that we are hoping that this consolidation exercise will provide us with is a further move towards digital transactions and online payments, something that I know many of our existing clients have already moved to without exact clarity on how they need to maintain those records. We are also we were expecting and we are hopeful that a number of the conflicts and confusions over the multiplicity of definitions will go away. It will also broaden the concept of employers and employees while eliminating the overall complexity of the Indian federal structure, which leads to labor laws having central laws with central rules as well as central laws with state rules. As already mentioned, the list of laws that will currently get consolidated or are currently getting consolidated under the Code of Wages are the Equal Remuneration Act, the Minimum Wages Act, the Payment of Wages Act, and the Payment of Bonus Act. And while we are hopeful that all of these various acts will come together and give us a consolidated view, today what we are going to discuss are some of the benefits related to the compliances of the, some of the benefits of the benefit related compliances, some of the benefits related to compensation related compliances, as well as the implications of the changes that are happening with regard to the inspection procedure and revised penalty structure. Once again, sincerest apologies for the delay in starting this session. We are hopeful that we'll be able to make up some time on the way. If you have any specific queries, do write into me at indranil.chaudhary@lexplosion.in. I'm aware of the fact that this is our first open webinar, so there could be a number of people who are joining who have not experienced Lexplosion as on today. Please don't judge us by this delay in starting the webinar. It probably does not reflect fully on our technology skills. Do visit our website www.lexplosion.in, and I'm reasonably sure that you'll come out thinking that we are a professional organization. With this, I will hand over to Zahid Tarafdar, a senior lawyer with Lexplosion, who has been involved with the area of labor laws and labor audits for over a decade now. Over to you, Zahid. Thank you very much, everyone, for your patience.
Thank you, Indranil. Good afternoon, ladies and gentlemen, once again. Thank you for being with us. In this part of the webinar, we will be discussing the benefits which the Code on Wages 2019 promises to deliver. Now, it is obviously a fact that you people who are HR professional or from the admin team will be mostly feeling the changes or carrying out the changes in handling issues regarding benefits and compensation of employees who work for you. Now, there are various reliefs which the code promises to deliver, but with time, we will be only getting a clarity as the appropriate government comes up with the rules. We will start by looking at various conditions on the basis of which the existing set of 4 laws which are being amalgamated by this code applied or even till date applies to various establishments and industries. Starting with payment of wages, the payment of wages in its definition of establishment clearly lays down 8 different industries or workplaces to which it applies. Starting from things like mines, oil fields to the manufacturing sector, and some more are covered under the ambit of Payment of Wages Act. Not only that, the applicability of payment of wages is dependent on a threshold of monthly salary which an employee or worker draws from the establishment, which is capped at 24,000 rupees per month. Moving on to Payment of Bonus Act, now this law is applicable to all types of industries who hire 20 or more persons across the nation. Across the nation, because as we all know that this is a central act which only has one central rules. Till date, there has been no state specific legislation under the related to payment of statutory bonus. This law again has a limit of a salary which is capped at 21,000 rupees per month. It means that anyone who earns up to 21,000 rupees of salary per month gets covered within the Payment of Bonus Act and thereby becomes eligible to get statutory bonus. The next law which is getting amalgamated by this code is the Minimum Wages Act. This law, as we all know, applies to the scheduled industries and scheduled employments, which the Central Act and various state rules come up. There is no dependence as such on the number of persons employed by you or the salary paid by you to them. The last law which we will discuss now is the Equal Remuneration Act. The applicability of this law is not dependent on any industry or establishment which you run. The applicability is determined by employer and it pretty much applies to every employer in this country. There is also no threshold of number of people employed by you or the salaries you pay to them. We will move on to now compare the status of applicability vis-a-vis the code and the laws which exist today. In the lower part of the screen, you will see that we have tried to analyze it. Now, starting with Payment of Wages Act, right at the beginning, there is a change which has happened. The law is now applicable to all industries, as well as the salary threshold of 24,000 rupees per month has been removed.
So Zahid, I think what becomes relevant at this stage for all the people who have stayed on with the webinar to understand is that there are 2 critical changes that are happening. One is, of course, that the 8 specific industries that were mentioned in the Payment of Wages Act has been taken away, as a result of which this act now becomes applicable to all industries. But there's another aspect to this. The Payment of Wages Act had to be read with state rules. So outside of the 8 industries which were stated in the central rules, various states through different rules had incorporated other industries, which only led to more complication and confusion in the minds of the employer, because in some cases the Payment of Wages Act applied, and therefore the wage period, etc., needed to be followed. And in some other cases, for the same business in other states, it did not. With all industries being equally made involved with the Payment of Wages Act, this confusion and the essential contradiction that was there goes away. And I thought it's an important point for the audience here to know about.
Yeah, absolutely. Thanks, Sunil, for adding that. Moving on with the Payment of Bonus Act, as the chapter contains in the code, the number of employed person remains unchanged. It still is applicable to establishments hiring 20 or more people, but the threshold of 21,000 for now has been removed, with only giving an option to the appropriate government to notify this threshold at a later stage.
And there again, Zahid, there is an interesting point here. As we all know, and I know that this session is being attended primarily by professionals who are in this space, the Payment of Bonus Act was being currently read only with the central rules, which meant that the threshold of 21,000 was uniform across the country. With the inclusion of appropriate government, which in this case means essentially states, as a part of the Payment of Bonus Act, Payment of Bonus definition, what is happening is there's an opportunity for individual states determining threshold as well. The outcome of that could be that, and this could put, we are hoping that the rules will give more clarity, but at this moment we are not sure whether that could mean that some states will have a threshold of 21,000 while others will have a threshold of 30,000, so on and so forth. So that's again something which we will have to wait for the rules to come and clarify. But for the moment, it seems that it's quite possible that the Payment of Bonus Act will apply differently for different states, and the thresholds might be different. And I know that there is another point which we would also like to make at this stage, that there was one certainty with regard to the Payment of Bonus Act that was currently provided, which is that threshold would be 21,000, and for people earning more than 21,000, the threshold would be considered as 21,000 across the country in all cases. However, what the wage code does is it adds an additional level of don't know whether the word is complexity, but an additional level of clarity. It says that if the minimum wages of a person is higher than the threshold that is set, then the bonus has to be calculated on the basis of the minimum wages, which means that in a case, if the threshold, let's assume, remains at 21,000, but if the minimum wage is 25,000,
right,
then the employer will have to calculate bonus on the basis of 25,000. This also means that this uniformity, which made the calculation of bonus and therefore the payment of bonus relatively easier, is going to become a little more complicated now, assuming that in some cases the minimum wages are higher than the 21 or whatever is the threshold that is determined for that particular industry or that particular state. Sorry, over to you again.
Yeah, rightly pointed out by Sunil, and this might be an area, of course, of concern for the finance team, for various people who are listening into this webinar. Moving on to the Minimum Wages Act. Again, significant change here. The concept with which Minimum Wages Act was introduced in this country has been thrown away. Now we do not have any scheduled industries or employment as such to determine whether any employee would fall under the ambit of Minimum Wages Act.
And this is supremely critical. This takes away a major source of confusion across businesses which were working in different states, because the scheduled industries and the scheduled employments varied from state to state, as a result of which even if a company was employing the same or doing the same business in multiple states, in some states the Minimum Wages Act applied, in some it did not. Additionally, of course, the minimum wage rates in themselves were different in each of these states, which is probably something that will continue. By involving all sorts of employments as a part of this Minimum Wages Act today applies to every form of employment that is available in this country as of now. And that removes a major source of ambiguity.
Right. The last one of the law which is getting amalgamated by this code is Equal Remuneration Act. Thankfully, there is no surprises there. There has been no changes with regard to applicability or the compliances which you need to comply with under the law. Moving on to the next section, where we will be discussing the terms which have a common definition under the code, in contrast to the multiple definitions under various laws which the code amalgamates. We have picked up on the left hand of your screen three search terms, being wage, employer, employee. And there are three laws which are revolving around those words, which are minimum wages, payment of bonus, and payment of wages act. Now, all these three laws define these three terms to various extents, covering and in many parts leaving out certain aspects. Whilst in some cases, under the definition of employer, the legal representative was included in the case of a factory. In some cases, it did not. In some cases, the definition included the owner of a factory, while in some cases, the definition excluded the owner and only vested liability on the occupier. Now, this definitely, therefore, led to various multiplicity, often led to confusion at various levels, be it with ascertaining the implication of a term, understanding its meaning to determine whether or not you or any person employed by you are covered within the four corners of the term, and thereby come within the ambit of the relevant law for which the definition is being looked into. Now, what this code aims to do is, it is to unify many such terms which are common to various laws by giving them a common definition. Some examples are like the term establishment. It was defined under the Payment of Wages Act and the Payment of Bonus Act.
And what is interesting, Zahir,
yes,
and I'm sorry to be butting in again, is how widely variant the definitions were.
Yeah.
Right? So in the Payment of Wages Act, like we have already discussed, only 8 identified industries were considered to be establishment. Whereas the Payment of Bonus Act talked about pretty much all sorts of establishments, including public sector as well as undertakings, as well as all private establishments. Now, this widely different variation meant that for an employer, there was this requirement on one hand to keep track of all the different types of establishments that were being identified under the under the Payment of Wages Act, while with the Payment of Bonus Act, they had to provide bonus to pretty much all employees. With the definition of establishment being changed as it is now, that confusion is likely to go away.
Right. Now, what we will do is, we will do an analysis of what the definitions are under the code. In the first part, which deals with establishment, you will see the definition now includes any industry, trade, business, manufacture or occupation which is carried on by any establishment and includes government establishments as well. So this basically lets you know that the point that I mentioned earlier also, now payment of wages is not only restricted to the 8 different types of industries, it now covers all businesses, industries and trade, covers all types of location, not only restricted to mines, oil fields, etc. It covers your factory, your offices, your branch offices, warehouses, all types of operating units from which you can run your business. And it covers every type of ownership as well, as Indranil pointed out, be it in the private sector or in the government sector. Moving on to the next term, which has been unifiedly defined by this code, is the term employee. Now here again, it has been left very wide open. This is probably the most conclusive definition or inclusive definition which is there given under this code compared to the definitions that existed under the 4 different laws. Here it says employee means any person employed on wages by an establishment. Establishment, of course, covers everything, pretty much everything, to do any skilled, semi-skilled or unskilled, manual, operational, supervisory, managerial, administrative, these 3 words are in red and I'll come back to it why it is so, technical or clerical work for hire or reward, whether the terms of employment be express or implied. Now, only thing which is to be noted here is apprentices have been excluded from this definition, as well as for worker, which we will come to in a bit of time. Now, persons who are employed to do supervisory work, managerial and administrative work have been included in this definition. We will quickly move to the definition of worker, where besides covering all other types of employment, the persons who are employed in a managerial capacity or who are given in administrative capacity have been left out. Also, people who are working with a supervisory role drawing salary of more than 15,000 rupees have been kept out of this ambit of the definition of worker.
So Zahir, will I be right in saying that all workers, as per the new definition,
right,
are employees?
Right.
But all employees are not workers?
Absolutely, Indranil, because clearly the word employees also covers the person who I employ in any establishment to a managerial role or to play any administrative function or any supervisory role, in fact, without any salary threshold. Whereas the worker does not allow me to call, in fact, it does not allow me to call any person as a worker who is a manager or is playing an administrative role. And it also leaves out anyone who is playing a supervisory role, drawing a salary of more than 15,000 rupees.
Right. So which essentially means that if one goes into the code of wages and looks through the entire code in detail, they will realize now, barring for the portion on minimum wages, and,
yes,
and I know that we are jumping a few slides and we'll come to minimum wages in greater details later, but barring minimum wages, which is restricted to workers, which is essentially managers, administrators, and people in a supervisory role earning more than 15,000 rupees are being excluded. That everybody, for all other laws, irrespective of whether it's bonus, whether it's payment of wages, whether it's equal remuneration, all forms of employment are covered. And these have very interesting ramifications, as we will come to in a short while.
Yes, right, Indranil. Moving on to the fourth defined terms which the code has included is the term employer. Now, employer, right at the beginning, it says anybody who employs directly or indirectly, of course, specifies, relates to employees, workmen hired through contractors in your establishment. Now, for government establishment, it's the authority who is the head of the department. And in case where no authority is specified, then it is the person who has ultimate control or the chief executive of that authority. Interestingly, in the definition, Indranil, for factory, occupier and manager has been included only. While in the Payment of Bonus Act, which still exists today, the owner was also included. Now the owner is left out from this definition.
That's again very interesting that the term owner has been specifically excluded, rather not mentioned. Which leads us to suggest, and I know that we were discussing this a little while ago,
right?
And it came up, as a matter of fact, in a conversation with one of our clients, that if you are currently, for example, the owner of a factory, but then have leased it out to a third party for operations, today there was this vicarious liability and this sword that hung over your heads about whether, as the owner, you were still liable to pay wages at the whatever at the minimum wages,
comply with EHI. This is labor, but any compliance for that matter, right?
Even if and when the occupier was not complying. But now with the definition specifically excluding owner, the advantage that they have is they will not have to worry about this sword hanging over their head, and it's clear that it only applies to occupiers. So that definitely, especially in the case of factories, has clear benefits, and something that is probably probably our colleagues on the call or on the webinar will appreciate.
Yeah. Only if they're not working out of a factory which they have leased in their name, and attack that. Continuing with the discussion, ladies and gentlemen. Now, legal representative of owner from the ambit of employer of a factory has been included in this definition. Now, for establishment, legal representative of deceased employer has been included. I'm sorry, from the ambit of factory has been excluded, while it has been added for the from the ambit of any other establishment.
So essentially, the employer today has a much broader meaning. So as we will see as we move further down these slides, we as individuals would become employers for a driver or a domestic help that we might be employing within the meaning of the wage code. And that obviously comes with its own set of compliance obligations and requirements. Apart from that, what it is doing is it is clearly bringing in the concept of the legal representative, which becomes extremely critical, especially with regard to proprietorships, where previously, once the proprietor passed away, there was oftentimes a confusion on who the obligations devolved to. What it also does, and is definitely a sign of the things to come, is that it includes the definition of it includes contractors within the meaning of the definition of employer. And contractor, while the Contract Labour Act in itself has not become a part of the current discussion and will be a part of another of the codes that will come up later, but the definitions of contractor and contract worker have been clearly laid down here, and that has its own set of implications, which I know we will be coming to shortly, and I do not want to jump and go in there right away.
Yeah, yeah. Only thing is that in general, I'd like to add here is under the definition of contract labor, they have also included interstate migrant workmen, which clearly suggests that probably they are looking forward towards merging these two laws. However, interstate migrant workmen in itself has not been defined, which has a clear definition under the Interstate Migrant Workmen Act.
And I suspect that most of that will be dealt with the second code, which is hopefully going to get presidential assent again in the next few months, and we will hopefully be able to get some more clarity once that happens.
Yeah. Okay, moving on, ladies and gentlemen, the part of wages, this part I will not cover it now. That will be covered by our head of finance, Mr. Saurav Chaudhary, who is the chartered accountant.
Yeah, I think we just realized that this is so complex and so specific, so numerical, that it is best not touched by lawyers like us, and is taken up by Saurav, who has the right expertise to be able to do that. And I know that there are several people from the payroll departments who have joined today's webinar as well, and who have patiently waited for this section. So we will pass it on to Saurav very soon, so that he can take you through the implications from a computation perspective on the definition of wages as they stand today and as they are being modified under the wage code.
Yeah. Moving on with our discussion, now we'll be looking at the various components which will be considered for computing or fixing the minimum wage, which will be payable to all employees or workers.
And basically, we have covered the definitions. Now is the time to look at the four concepts which were there under the payment of wages, the payment of bonus, the Equal Remuneration and the Minimum Wages Act. The first of this will be the definition of minimum wages and the concept of minimum wages, and how that is changing under the new scheme of things. So over to you, Zahid.
Yeah, absolutely. Now, under the existing Minimum Wages Act, the cost of living index was considered by various governments to fix minimum rates of wages. Under the code, on the left-hand side of your screen, you will see the various additional factors which will now be considered for fixing such minimum rates of wages. Now, like things like skills of workers, whether it's unskilled, semi-skilled, or highly skilled, the geographical area will also be considered for fixing the Minimum Wage Act. So, for example, it will be interesting to see how it pans out in general. Like in West Bengal itself, we have a state called Darjeeling, and we have a district called Darjeeling, and we also have a district called
Birbhum. Yeah, and that's very interesting. Currently, we have minimum wages by state. By determining geographical area as also a point of consideration, it is now possible. And why I know that Zahid mentioned Darjeeling, a place that he loves to go to as well, is because it's just geographically very different from the rest of West Bengal, and therefore it's quite possible that the same work which is considered to be arduous because of the levels of humidity in a district like Birbhum or one of the southern districts of West Bengal might not be considered arduous when it's being done in Darjeeling because of the climatic conditions there. This is probably true in many other places. For example, in Tamil Nadu, the same work while being done in Ooty might be considered not to be arduous, whereas when it is being done maybe in Chennai, it might be. So these are not considerations that we are used to. We had not seen them. So geographical area, arduous nature of the work, humidity that is normally difficult to bear, things, if people are doing underground work, will all be factors which will now be considered for determining minimum wage, which of course then brings us to the larger concept of the floor wage.
Right. So considering all these factors, including the erstwhile factor also, which is cost of living index, the central government will consult all these factors with the state government and the central advisory board to come up with a floor wage. Now, what is floor wage? This is absolutely a new concept which is being introduced by this code, we all know now. Now, simply put, floor wage can be called to be the national minimum wage, which is to be set by the central government after relevant consultations Now, needless to say that for fixing floor wage also, they will be considering all the factors which are mentioned there. As you are now all aware that the central government today also issues certain central minimum wages. So just wanted, so there might be some confusion because I'm not hearing right now. I'm not hearing. Of course, I'll be looking forward to your questions which you post. But currently, if anyone you have in mind that what is the difference that is going to happen today, also the central government comes up with minimum wage schedules. Tomorrow also it's going to remain the same. They're just going to call it the floor wage. Now, I just want to spend a minute on this, that today the situation is that the central government fixes minimum wage rates in relation to any scheduled employments carried on by the authority of the central government or say a railway administration or to specific industries like mines, oil fields, major ports or any corporation established by a central law. Say for example the Life Insurance Corporation of India, or if you talk about Employee State Insurance Corporation in India. So these the rates at which the minimum wage will be paid to such bodies or organizations is decided by the central government. Otherwise, the state government comes into the picture for deciding wages for other establishments.
So, as a matter of fact, Zahir, while floor wage is already being discussed, there might be certain federal questions asked by some of the states about the right of the center or whether it's fair on the center to fix a floor, because in some states which are economically not doing as well, if they have to go above that floor, it might cause some of their current employers some hardship. But what seems clear as of now is that there will be a floor wage.
Correct.
That floor wage does not have to be the same across all states or across all geographies within the same state.
No, right.
So it is quite possible that the center might actually fix different floor wages for different natures of employment, even within the same state.
Yeah.
But a floor wage will be fixed. And what is quite clear is that once that floor wage is fixed, the states will be only able to fix a wage above that floor wage. And I know that as we move on, we'll also see how that floor wage, if that minimum wage, if it's already much higher than the floor wage, cannot be reduced to bring it closer to the floor wage.
Right.
And all of that is quite interesting because that's very different. So now we will have a situation where, first of all, there are no scheduled employments or scheduled industries. So all industries are covered. On top of that, we have this floor wage concept, which also brings us to another very interesting point, Zahir, which is now that there is no defined set of industries.
Right.
As of now, what we used to do on our clients' behalf, or what our clients used to do, is they used to ask us questions like, hey, we employ X type of employees.
Correct.
Are they covered? Now, we used to go into a schedule, we used to see whether they're covered and used to give an answer. If we did not see an exact reference, we would try and find something which was in the same area.
Right.
But now that all employments are covered, the question that will inevitably be asked is, if there is no reference to anything similar to that in a schedule, is it going to be the floor wage for that state which will be considered to be the minimum wage, or will we have to look at some other criteria to determine it? Obviously too early to take a call on that, but something that probably us and our clients need to keep in mind, because as we move forward, this is definitely going to be a point of concern or a point of discussion.
True, Indranil. But at this stage, there is just a hint, and it says absolutely nothing at all. But we, on our research, we found out that minimum wages chapter under the code, the chapter which deals with minimum wages, focuses on workers and not employees. So can this mean that persons who are specifically excluded from the definition of employee may not be covered in minimum wages? And with the stress on that may, because today we are really not in a position to tell one way or the other.
Yes, and I think what we have seen is that while it seems that the minimum wages portion is specific to workers,
yes,
the entire section on minimum wages under the wage code starts with the word employee.
Right.
So while that confusion was supposed to go away, unfortunately, because of probably some framing issues, that confusion remains. But we are hopeful that will be clarified. And from the rest of the section on minimum wages, what seems to come out reasonably clearly is that the minimum wages section is defined, is restricted to workers, which essentially means that managers, administrators, and supervisors above 15,000 rupees per month salary will not be covered under that. But that's something that, like you said, still will have to be discussed
Yes.
and finalized.
Yeah, we will have to inevitably wait and watch for that. Moving on, we will now be discussing some key points under the minimum wage chapter as given under the code. So we discussed what are the various components which will be taken into factor for fixing the rates of minimum wages. Now we will be discussing the various components which can come together to form the minimum wage which you ultimately pay to your employees or stroke workers. The first being it can be the basic wages along with the allowances which you give off. The second can be a combination of basic with or without allowance plus the cash value of concessions in respect of supplies which you provide to your employees on a monthly basis. The last being it can be also an all-inclusive rate including the basic rate and the cost of living allowance plus any cash value of concessions which you give to your employees. Now again this part will be taken up by my colleague Saurav Chaudhary later on with elaboration in terms of numbers to help you understand how it's going to pan out. Now, employees' entitlement to full wages is the second part which I am going to cover. So, say for example, an employee comes to work at your office and his daily working hours is 8 hours and he does a work for you in your factory and he is done with his day's job for within 5 hours and you do not have more job to give to him to work for the remaining 3 hours. Now in that case, there was a gray area now that has been in terms of what you need to pay for that particular day to your employees. Now it has been clarified under the code. It says that the employee will be entitled to get full day's wages for no fault of his to work for those remaining 3 hours for which he couldn't be
And this is
given
interesting,
adequate
Zahir,
work.
in the current economic environment where there is certain amount of reduction on work that is happening in some locations.
Right.
Some of the factories are working only half a day or a portion of the day. Some of them are having to remain shut for some periods. What this, if the wage code was applicable today, which it is of course not, what would have happened is that the day's wages would still have to be paid unless the reason why the person is not in office can be attributable to the employee.
Yeah.
What is clear is that the full day's wage will still need to be paid.
Yes.
This was an area of uncertainty. There was some amount of confusion, and we know that the good employers, which is mostly our clients, would inevitably err on the side of caution and still pay the salaries. But some of the more unreasonable employers or the which is essentially all those who are not our clients, would go ahead and try to bypass the law and take advantage of this area of grey. So which is likely to go away with the passing of the code of wages.
Yeah,
and my sincerest apologies for this extremely unfair humor.
Nicely put in, Rinil. But so basically, the moral of the story is: do not deduct wages or pay less to employees for the reason that you could not provide adequate work to them to work throughout their working hours. Moving on. Now, another two things which the minimum wage chapter under minimum wage also clarifies is if a person does multiple jobs which has prescribed limits of multiple minimum wages. Now, as an employer, then you will have to keep a tab on the time the worker spends doing each type of such job for which there is a specified minimum wage, and the worker has to be paid proportionate to the time spent that he has spent doing each of such job.
So this is again quite interesting. So, for example, today if a person is performing a mixed service, which could be broadly divided into two parts, and say for half the time they're doing a particular job which is where the minimum wages are fixed at 12,000 rupees per month, and is doing something else for the other half which is fixed at 18,000. Again, the good employer would probably err on the side of caution and pay them a minimum wage at the rate of 18,000. But the more prudent or the employer would probably go with the 12,000 number. It's now clarified that at the minimum they'll have to be paid 12,000 for the 50% and 18,000 for the other 50%, meaning that overall they'll have to be paid 15,000 rupees per month to make it fair. And this is again important clarification, because while our personal experience with most employers suggests that they would like these clarifications. They would like to remove these shades of grey because it makes operations and compliance a lot easier rather than depending on consultants and people like that to take calls which then later can be proved wrong and therefore lead to penalties and past dues. So so that's an area which will hopefully be clarified now.
Yeah, a clear scenario is always more welcome than an ambiguous position. Now, moving on, there are certain exceptions to hours of work and rest, which is also provided under the code. So that can be of any of the four situations which is there on the right hand side of your screen. In case of any emergency situation of unforeseen event happens, then you can make your employees work for more hours than has been prescribed. Or say the employee works is of a nature of preparatory or complementary in nature, which has to be completed within the day, which takes it beyond the normal working hours. Or say for any technical reason which has to be completed before the duty is over, say something like which we faced in during the start of this webinar, maybe the work entrusted and the last one being the work entrusted cannot be completed except times dependent on irregular action of natural forces.
And I think some of this was already there.
Some of it, absolutely.
So I think this is not significantly different from the position that is existing in law today.
Right.
What it does through the unification of the code is makes it equally applicable across all aspects of minimum wages. So that is the additional clarification. But as a concept, I don't think this is not absolutely brand new.
Moving on to the next slide, you will see in your screen we have drawn a table which does a comparative analysis on the time for paying wages.
So essentially, we are now done with minimum wages for this discussion. We are now moving to payment of wages, which is the next section. Payment of Wages Act, like we discussed previously, had this entire concept of 8 specific types of industries which were covered, so on and so forth. Now the payment of wages applies to all of us equally. That makes, like we have discussed, life a little more clear. With that, of course, comes the requirement of knowing by when wages have to be paid. Till now, if your industry was not a part of any of the industries listed, you could still follow your own internal processes and policies.
Right.
That no longer will work. Now there is a clear line of sight as to what it is, and I will pass on to Zahid to tell you what that is.
Yes, Indranil. So while the daily, weekly, and fortnightly work wage period, you will see that for daily it has to be paid. The wages have to be paid right at the end of this shift. For weekly, it has to be paid within the last working day of the week. Before every that has also to be before every weekly holiday. For fortnightly based wage period, it has to be paid within the second day after the fortnight ends.
And what is interesting to see is that currently, while the wage period could be anything up to a month, so it could definitely be daily or weekly or fortnightly, there was no clarity on by when these wages had to be paid.
Anything short of a month.
Right. So for periods short of a month, the assumption was that the payments have to be made at the same, as per the same rules as applies for the monthly wages, which for 1,000 employees or less was within the 7th of every month, and for 1,000 employees or more was within the 10th of every month. So what most employers did was to avoid confusion, irrespective of daily, weekly, fortnightly, or monthly. Payments were made simultaneously for all employees. That cannot happen anymore. So for a daily worker, the payment has to be at the end of the shift. For a weekly worker, it has to be at the end of the week, and before the holiday. And for monthly workers, where there was this difference between less than 1,000 and more than 1,000, it has now been made uniform to the 7th. Now, this makes it very interesting, Zahid. I know that most people who are on this call probably don't employ daily wage workers. But what we need to keep in mind is that by virtue of the Contract Labour Act, even if any of their contractors employ daily wage workers as contract workers to do their work as principal employers, they become responsible. So, and as we know under the Contract Labour Act, there is an obligation on the principal employer to check whether payments are being made and whether they're being made in a timely manner.
Right.
That means that now for all the daily wage workers, the employer, the principal employer will actually have to keep track on whether the payment is being made at the end of the shift. Similarly, for weekly, they will have to make sure that the payment is being made at the end of the week, which adds obligations on the principal employer and will probably be of interest to a lot of the people who are currently on the webinar. Apart from, of course, the basic fact that even if you had more than 1,000 employees and were covered under the under the Payment of Wages Act and could therefore pay by the 10th of the month, there will be a certain hit on the cash flow cycle because now the payment will have to be made with it by the 7th of every month.
That 3 days is gone. Absolutely, Indranil. So there is some homework there to check with the contractors of people who are listening in, like as to how many workers they employ on a non-monthly basis or period lesser than a month. Moving on now, as you see in your screen, now we will be discussing the steps. This is, of course, further to the steps taken by the government towards making and promoting various digital platforms for all transactions and statutory filings, as well as the interactions with the government authorities. Now, here the code makes room for paying salaries through electronic and digital mode. So I know.
Thank God for that,
right,
because I think most of our clients and people on this webinar would be paying salaries through the electronic means.
Yeah.
All that was there till now was an ability to pay by check. That too just came in 2017.
Right.
So which meant that till 2017, an employer actually had to take approval from the employee to even pay by check. And the concept of electronic and digital mode was not even clearly stated. While we were mostly therefore then in violation of the Payment of Wages Act and still did it, but thankfully most of our employments were not covered by under the 8 industries.
Right.
But now it is absolutely clear that payments can be made in electronic and digital mode. What will need to be looked at once the rules come out is how the records of that need to be maintained. Because currently all payment related records need to be maintained in registers. If you make digital payments, it doesn't make any sense to maintain them in registers. We are hopeful that that better sense will prevail, and therefore the rules will clarify that for electronic and digital modes, the records can also be maintained electronically or digitally. But of course, that's something that we'll have to wait for.
Right. Another interesting aspect here in there is a catch. Now, the appropriate government in this case has been empowered to specify certain industries and establishment where payment has to be or will be made through checks and bank account only. Currently, I can only think of people who probably when bank check, I cannot think of the situation.
I can clearly think of some situations where this becomes very interesting. When again, directly for most of our clients, probably not, because they're already probably paying electronically and digitally.
Yes.
But there are again the contractor situation. So the Contract Labour Act says that if a contractor is not paying its workers, then the obligation moves to the principal employer.
Right.
The converse logic therefore suggests that if your industry is specifically covered as an industry which needs to pay their salaries electronically or digitally, that potentially might mean that your contractors for that particular part of the work will also have to pay their employees electronically and digitally. That leads to an additional level of monitoring, which will hopefully give a better situation at the end of the day, but in the initial period it might lead to a certain amount of confusion. But what is very interesting, of course, is that in the bonus section, which we will separately discuss as well, there is actually a reference that the bonus has to be paid only electronically into the bank account.
Right.
Now, this is very interesting. I would urge all the people on the webinar to take a note of this. Bonus has to now be paid electronically into the bank account. So no other means has been, at least for the moment, stated.
No.
It's quite possible that the rules will add some more clarity and at least allow checks to be paid. But at this moment, it just talks about electronic payment of bonus, which is quite interesting and probably goes in the direction that is being at least currently being pursued by the centre in India. But how it really pans out at the ground, one will have to wait and see.
Yes, Infinite. Moving on. I come to the last part of my section of this webinar, but not at all the least important aspect, because I have saved the best for the last. Now, we all know that under existing laws, provisions are there to ensure that you make payment within a certain number of days to people who are retiring, people who are superannuating from your company.
But most importantly, people who you are terminating.
Correct. People who are terminating, that part is also covered. Now, in general, this very interestingly, this adds the cases of resignation as well. So now
that, Zahir, is very interesting, because that essentially means that if an employee resigns,
yes,
an employer will now have to pay within a certain period. And if I'm not mistaken,
2 working days.
That's 2 working days.
That's right.
Now, for large organizations which have thousands of employees, where potentially several hundred are resigning every month, and obviously not on the same day, that means that if somebody is resigning on the 3rd of the month, then unless there's a holiday in between, they have to be paid by the 5th. If they're resigning on the 7th, they have to be paid by the 9th. Now, that is very serious work for the payroll team, but more importantly, might require a significant amount of tampering or tinkering with the existing ERP systems, which probably are not fed with this kind of logic, where you can, choose the date of resignation, and then by default, the payments are made within 2 days, and 2 days is anyway a really tight timeline, which was understandable for
in case of termination or retirement, where you have time, where you need to decide
plan. But in resignation, you don't have that. Of course, people typically have notice period, but even then, what is interesting is when the committee initially gave its report, this period was 2 weeks. That has actually been reduced to 2 days.
Right.
And that makes it really tight for employers. So, all the employers on this call, of course, we all as employees will rejoice, because now we know that within 2 days of our last date of working, we'll have to statutorily be paid our wages, or whatever, full and final settlement has to be done. But as an employer, people in the payroll team, people working on technology and therefore involved with ERP, do take note of this, that even for resignations, you need to, the moment somebody resigns, depending on the notice period, you immediately need to trigger the system to make sure that payments are released within 2 working days. So that's a very interesting point, definitely worth taking a note of, and definitely worth saving for the last say.
Thanks, Indranil. Thank you, everyone, ladies and gentlemen, for hearing me through. I hope you've liked it. I will be happy to take on any questions on this section, and of course, all other sections also. I will now pass on the mic to my colleague, who is a labor lawyer also, Madhura Bagchi, who will take you through the remaining portion of the benefits of the code. Thank you so much.
Hello everyone, this is Madhura. So I'll discuss the effects of the code on equal remuneration, the concept of scheduled employment, the position of unorganized sector of employment, the inclusion of a new ground for disqualification of bonus, and certain increased responsibilities of employers. Now, equal remuneration, as you're already aware, under the Equal Remuneration Act, you are required to pay equal remuneration to male and female employees if they have the same skills, are exerting the same effort, and are burdened with the same responsibility, and are working under similar circumstances. Now, what the wage code does is that it includes a new aspect of same experience. So now, equal remuneration has to be paid to employees who have not only the same skill, are exerting the same effort, or have the same responsibilities, but also who possess the same experience. In this regard, I'll make a quick reference to the fact that, consistent with the current Equal Remuneration Act, any difference in the skills, efforts, responsibilities, and now experience among the employees will not be considered if they are irrelevant in relation to the terms and conditions of their current employment. Now, this addition of same experience has still still some gray areas are still remaining under the code.
So, Madhura, what is probably worth considering is what the implication of this will be. Now, I think it can be used in both ways. While there might be some marginal discrepancies in the skill or the effort, if a woman employee has higher experience or similar experience, which oftentimes happens because women do take breaks from work and then come back, and therefore the experience over time has probably added up. It can be used in their favor, but some employers might also use this experience, which is not being clearly defined, as you just mentioned, to discriminate between the men and women employees, and use the experience bogey to not pay the same salary to a woman, or if that is the issue that is raised, use that to say that therefore you are being paid lesser.
Yeah, just because the male employee has more experience.
And maybe it's interesting, and it's probably worth taking up with the center to see if a specific definition or some conceptual clarity on what experience is added, so that this ambiguity goes away. And it's probably worth considering that.
You're right, sir. So experience still it's being defined by either the center or by the code if it goes through any other amendment. Till then, there's this loophole would remain. The next concept we would consider here is whom the equal remuneration has to be paid. So currently under the Equal Remuneration Act, it is said that equal remuneration has to be paid to men and women workers who are engaged in same work or work of similar nature. But the Code of Wages doesn't specify male or female workers. What it says is that no discrimination relating to in wage-related matters can be made among employees on the ground of gender. In the light of the recent passing of the Transgender Persons Protection of Rights Bill 2019 by the Lok Sabha, we can expect that now even transgender employees would be eligible for equal remuneration. So as per the Equal Remuneration Act, you are supposed to give equal opportunity and equal remuneration to men and women workers, and now under the wage of code, you will be required to pay equal remuneration to even transgender workers, provided they have the same skills, are exerting the same efforts, are working under the same circumstances as their male or female colleagues.
And you make a very, very interesting and progressive point, Madhura. I don't think not everybody would have been able to interpret the law the way you have, but to be able to read in the Transgender Persons Bill of 2019 into the wage code to also make that clarification, because it's very valid, because earlier it was very specifically mentioned men and women. By taking that out, clearly transgender persons are also being included. In the way the society is progressing in the light of recent Supreme Court judgments, it becomes important and interesting for us to all consider as employers and keep that in mind while making payments under the Equal Remuneration Act. And I know that our Saurav will discuss the implications of the Equal Remuneration Act later, but yeah, I think it's a point which is definitely worth making.
Thank you. Moving on, you must have seen that in the previous slide, under the Code of Wages, it has been mentioned that no discrimination shall be made among employees on the ground of gender in matters relating to wages by the same employer. Now, this term "same employer" is not present under the current Equal Remuneration Act. From this term, we can say most of you on the attending the webinar have large organizations spread across various states across the country, various cities across, in that state, and even within the cities you have multiple operating units. So say you have a number of offices in Maharashtra, and in one office you are only employing male employees and in the other you're only employing female employees. Would that exempt you from paying equal remuneration to your employees, to those male and female employees in the different establishments? The answer obviously under the wage code is no, because under the wage code, as long as the employees are employed under the same employer, even if they are in different units of the organization, as long as they have the same skill sets, are exerting the same effort, are burdened with the same responsibilities, and now have the same professional experience, they will be entitled to the same remuneration.
And another point which I would like to make in that context, Mathura, is that apart from, of course, different offices, since the definition of employer is fairly broad, it would also mean that if an employer is a group company, even if they have multiple different companies as subsidiaries, Equal Remuneration Act has to be followed across all of those group companies. So considering the definition of employer, even for group companies, even for employees who are not direct employees but employed through a contractor, the Equal Remuneration Act will have to be followed because of the definition of the addition of same employer, and that's the assumption we're making at the moment, which makes it quite interesting as well.
Moving on, we'll now deal with how the Code on Wages is, proposing to cover all employees within its purview. As was discussed by Zahir earlier in the session, that the concept of scheduled employment has been done away with. I'll just reiterate that point, but with a example. So currently under the current position under the Minimum Wage Act is that a fixed schedule is there, and only the employments listed under that schedule are the employments for which the government would fix a minimum wage. Not only the schedule under the Central Act, but also state governments come into play and they amend the schedule to suit the conditions of their respective states. This, as was also earlier mentioned, would lead to confusions. Now, the example we have given here is relating to the cement industry. So, in Assam, the entire cement industry has been added as a scheduled employment, whereas in Gujarat, only cement pre-stressed product industries have been added as a scheduled employment. So, while in Assam, anyone engaging in any kind of cement industry would be able to, just check the minimum wage fixed by the Assam government and pay the wages. In Gujarat, it would be a little more difficult as the employer would have to first, make sure that the minimum wage has been fixed for, say, asbestos cement factories or for cement pre-stressed products, and then only they will be able to identify the minimum wages and then pay minimum wages. Under the code, the proposed position is that the concept of minimum wage is being done away with. This in turn would guarantee minimum wage for all employees irrespective of their type of employment, and would also spare employers any confusion for determining which minimum wage is fixed for which worker of his industry. Another very interesting factor of this code is that it proposes to include unorganized sectors within its purview. Now, unorganized sectors would include even the drivers you are, employing to maybe pick up and drop your employees, or even the person who is, delivering water jars to your office. So even now, these workers would be covered under the purview of minimum wage, its timely payment, overtime wages, and even bonus. I'm pretty sure you must have some confusion as to, apart from these, drivers or people delivering food or water just to your office, why would inclusion of unorganized sector help you or matter to you in any manner? An interesting fact in regarding this would be that under this code, the inclusion of unorganized sector is referred to in such a manner that it would affect you as an employer not only in connection to your organization but also in connection to your domestic, also in the, connection with domestic workers.
And the interesting point there, Madhura, and I think this would be appreciated by people on the webinar, is that currently there is no specific definition of unorganized sector anywhere in the wage code. There is only a reference to the unorganized sector in the statement of objects and reasons. But what happens is within the wage code itself, there is a more specific reference to domestic work and people being employed for domestic work. And how this becomes relevant is there it is said that anybody who's being employed for any work at the residential level will get covered by domestic work. Interesting, considering that all of us, apart from being employers or employees, also play the role of a person running a house, and in that capacity, we probably have household help like cooks, support staff, drivers in our respective homes. Interestingly, under the new section or under the wage section 50 of the wage code, what happens is all of those people that you are employing at your residence, you will have to keep records of payments being made. As a matter of fact, if it's more than 5 people, you have to maintain records exactly like any other employer for all of these people with regard to payment of wages, with regard to payment of bonus, with regard to minimum wages. But even if it is less than 5, the wage code clarifies that you will still have to maintain these records. And if at any point an inspector wants to see them, you will have to show it to them. How it becomes relevant even to employers is, for example, if you have company leased accommodation, for example, where your employees are using the house, but you are the lessee for the property. In those cases, for example, the domestic workers that are being employed by by your employee will have to follow the same rules and regulations that are applicable for your own employees, because as the lessee of the property, there is a possibility that the obligation to maintain the compliances with regard to domestic workers falls on you, and that becomes quite interesting.
That is because, as was discussed by Zahid, the definitions of worker, employee, or employer, anyone directly or indirectly employed would be an employee. So that way,
absolutely.
yeah.
So that's very interesting. Has obviously far-reaching ramifications. Has very important ramifications in the social construct of India, where domestic workers have been a large part of the upper middle class and the middle class people's lives across the country, and have largely been ignored from the point of view of most labor laws. This how this eventually pans out through the rules will be interesting to see, but is definitely a groundbreaking path, step forward, and therefore needs to be taken into consideration by all of us.
Yes. So right now on screen, you will find some of the responsibilities on you as an organization, as an employer, towards your employees, including both organized and unorganized sectors. This would include payment of minimum wages, payment of bonus, overtime wages, their timely payment, and even maintenance of registers containing details of such workers, muster rolls, registers containing details of the wages paid, display of certain notifications like wage rates, wage period, and also issue of wage slips. Moving on, now I'll discuss on how the wage code would have an effect on the disqualification from bonus, like consistent with the current Payment of Bonus Act. The wage code also lists down certain grounds like fraud, violent behavior, theft, misappropriation or sabotage of any property of the establishment, because dismissal on grounds of which would disqualify the dismissed employee from payment of bonus. What this code does is that, in line with the various initiatives taken by the central and the state governments to ensure a harassment-free work environment for female employees, has included dismissal from services on grounds of conviction for sexual harassment as a ground for disqualification from bonus. However, an important point to note over here is that if any employee has been found guilty of sexual harassment, has been given a warning but not terminated, he will still be eligible for payment of bonus. Hence, as long as the employee is employed in the establishment, he is eligible for the statutory bonus.
So only in case of dismissal, yes, will they not have to be paid bonus. Yes. But still, it's a very, very interesting and important step forward.
So we have over here given a small instance for the same. So in like case A, a warning has been given but no dismissal had been made. So the employee would still be entitled to bonus. Whereas in case B, due to being found guilty of sexual harassment, the employee is dismissed from service and hence not entitled to any bonus. Next, we'll discuss the effect of the wage code on overtime payment. Currently, under the Minimum Wage Act, it states that any employee who works beyond the fixed hours of work is entitled to some excess wage at the rate of overtime wage as fixed by the state government. This concept of overtime has been spread over the different establishment specific enactments also, like Shops and Establishment Act and Factories Act. In most Shops and Establishment Act, as you may be aware, the state government has fixed the overtime rate at 2 times the normal wage rate. But since this power of fixing the wage rate is at the mercy of the state governments, there may be a situation where the state government fixes an overtime rate below this 2 times the normal wage rate. So to remove this possibility and to in a way help employees, what the wage code proposes is to guarantee a minimum overtime wage rate of 2 times the normal rate of wages. So even now the state governments would be able to fix the overtime rates of wages, but not below that 2 times the rate of normal wages.
So just like with minimum wages, where there is a floor which is being provided by the center, even for overtime, the center is saying that you cannot go below 2 times.
Two times the normal.
Like you said, in most cases it was anyway 2 times. There are instances where it is 1.5 times. So with this, and also now that all types of employment in all industries are covered, there is no ambiguity on what overtime needs to be paid. Overtime needs to be paid and has to be paid at 2 times the wages, irrespective of the nature of employment.
So at the onset, when I was introducing myself, I said that I would discuss regarding some increased responsibility of employers. One of such responsibilities under the wage code is that the shift in the burden of proof. Now, what happens is, when under the present payment of wages, payment of bonus or minimum wages act, when an employee files a claim for say non-payment of bonus or remuneration or less payment or unauthorized deductions, it's on the employee to prove that such non-payment has happened or that such unauthorized deductions have been made. Now this burden of proof has been completely shifted on the employer. It's on the employer to prove that the dues have been properly paid.
This is, again, I think one of the most interesting changes that is happening under the Code of Wages. Has obviously got far-reaching implications for employers. I know that you will discuss this in greater detail, but with the burden of proof shifting to the employer with regard to non-payment of remuneration, delayed or lesser reduced payment of remuneration or bonus, it means that employers will have to be a lot more cautious with
about
the
records,
that they keep, because the burden of proof is now on them, and unless they can prove to the contrary, they will have to pay the remuneration or the
and
bonus
also some penalty may be attached.
And also the some penalty might be attached, which is very interesting.
Another important aspect of the code is that the limitation periods for filing claims have been enhanced. So previously under the Payment of Wages Act, if the employee had to file a claim against the employer, the time limit was within 12 months. And under the Minimum Wages Act, the limitation period was 6 months. The Code on Wages proposes to enhance this limitation period to 3 years. With this enhancement in the limitation period and also with the burden of proof shifting, the employers will now not only have to be extra cautious in maintaining the records as you discussed a little earlier, but also this imposes a longer obligation on the, an enhanced obligation on the employers to preserve whatever record they have for at least 3 years. So within these 3 years, if an employee files a claim for realizing their statutory dues and the employer does not have the records in place, it may impose penalty on such employers.
Yes, absolutely. So on both these points, a much larger and a far more enhanced responsibility on the employer. Definitely a source of concern for especially small and medium enterprises, which do not have the same record retention systems, the same kind of support structures that larger organizations have. Becomes particularly relevant for contract workers, because again, as the principal employer, the responsibility will remain for an additional period of 2.5 years in case of minimum wages if somebody comes back with a claim. Therefore, not just with regard to their own obligations, principal employers will also have to make sure that the contractors, when they're conducting audits, when they're conducting self-assessments of their contractors,
are
they keep this in
maintaining
mind.
proper records.
Whether they're maintaining records for long enough periods of time, so that such claims, if they come up subsequently, are also being taken care of. Same with the burden of proof portion that you mentioned. Very important points. Thank you for making them, Madhura.
Thank you, sir. So now I'll hand it over to my colleague Saurav, who will take you through the different nuances relating to computation under the code.
Thank you, Madhura. Hello, everyone. In this part of the webinar, we will take you through the different definitions of wages provided under the existing laws as well as that in the wage code, and also understand the computational aspect of the term wage under the existing laws as well as the wage code. As you can see, while the Minimum Wages Act, Payment of Wages Act, and the Payment of Bonus Act define the term wage differently, the Equal Remuneration Act did not define the term. All remuneration was included in the Minimum Wages Act, the Payment of Wages Act, and the Payment of Bonus Act, while it specifically included only certain items and specifically excluded certain items. The Minimum Wage Act specifically included house rent allowance, while the Payment of Bonus Act included only the DNS allowance, and the Payment of Wages Act specifically included certain other items. The Minimum Wages Act specifically excluded a number of items, while the Payment of Bonus Act specifically excluded all allowances other than DNS allowance. Now let us have a look at the new definition of the wage as provided under the wage code. As you all can see, wages specifically include basic pay, DNS allowance, and retaining allowance, and excludes a few things, most notably the house rent allowance. As you all can see, while house rent allowance was specifically included in the definition of wage under the Minimum Wage Act as well as under the Payment of Wages Act, it has been specifically excluded from the definition of wage under the wage code. This implies that the employers might now need to reconsider the structuring of CTC of their employees who earn wages either exactly the amount of minimum wages prescribed or marginally higher than the minimum wages prescribed and has got HRA as a part of their CTC. We will discuss this in further detail while dealing with the computation aspect of the wages. It is to be noted that in terms of first proviso to the definition, in case the exclusions we just discussed exceed 50% or specified percent which the government may specify of the total remuneration, the amount which exceeds such percentage shall have to be added to wage. Similarly, in terms of the second proviso to the definition, for the purpose of determining whether equal wages are being paid to all genders, the exclusions which are appearing in red shall now have to be considered in the definition of wage. As you can see, house rent allowance, conveyance allowance, any payment on award or settlement, and overtime allowances, although excluded from the definition of wage, will have to be included for the purpose of determining whether equal wages are being paid or not. It is further to be noted that in terms of explanation to the definition of the term wage, where an employee is getting in lieu of any part of his salary a payment in a remuneration in kind, the value of which up to 15% of the total wages payable to him shall be deemed to form part of the wages. Now we'll understand the definition of wage by way of certain examples. As many payroll professionals are there in attending this webinar, my sincere apologies to those who do not find it interesting since we will be dealing with certain numbers. Let us take the case of Mr. X, who is an unskilled employee employed in ABC Limited and working in Zone A of West Bengal. As you can see, Mr. X's CTC is rupees 10,000 and the notified minimum wage for Zone A of West Bengal is rupees 8,177, which we consider to be constant for the purpose of this discussion, since the actual rates will be notified later on. Now let's see whether Mr. X is getting minimum wages in terms of the Minimum Wages Act as well as the wage code. As you can see, the wages of Mr. X as per the Minimum Wages Act is rupees 9,250, including various components and excluding certain components which we discussed in the exclusions part. The wage Mr. X is getting in terms of the wage code is only rupees 7,250 because HRA has not been included as part of the wage while it was included under the Minimum Wages Act. So as you can see, although Mr. X was getting minimum wages in terms of Minimum Wages Act, that is rupees 9,250, which is higher than 8,177, which is the notified minimum wage, he does not qualify to getting the minimum wage of rupees 8,107 under the wage code. This implies that ABC Limited will now have to restructure Mr. X's CTC either by increasing the basic pay or other allowances which are to be included in the definition of wage and reducing the amount of HRA, or will have to increase Mr. X's CTC in order to qualify the payment of minimum wages. Now let us see how Proviso 1 affects the computation of wage. As you can see, as discussed earlier, while the exclusions mentioned in the definition are not to be considered as part of wage under the code, in case the total amount of exclusions exceed 50% of the remuneration, the amount in excess of such 50% shall have to be added to the amount of wage calculated. Now in this case, Mr. X's total remuneration is 10,000 rupees, while wage as per the wage code without considering the effect of Proviso 1 is only rupees 4,250, which means that the exclusions from the definition of wage are rupees 5,750, which is more than 50% of the total remuneration Mr. X is getting. Thus, the amount of rupees 750, that is the amount which is in excess of rupees 5,000, which is 50% of the CTC, will have to be added to the wage for computation of wages. Even after adding the amount of 750, the total wage Mr. X is getting under the wage code is only rupees 5,000, which is less than the minimum wage prescribed, and hence the employer will have to restructure the CTC of Mr. X as discussed earlier. As already discussed, in terms of the second proviso to the definition, for the purpose of verifying whether equal wages are being paid to all genders working in the same nature of work under similar circumstances with similar experience and skill set, some of the exclusions need to be included in wage. To understand this better, let's take example of Mr. X and Miss Y, who both are working in ABC Limited at the same designation in similar nature of work and have seen similar qualification and skill sets. The CTC of Mr. X is rupees 10,000, which is marginally higher than that of Miss Y, which is rupees 9,930. On computing the wage as per wage code without considering the effect of the second proviso, it appears that Mr. X is getting rupees 7,250, whereas Miss Y is getting 5,390, and apparently gender equality is not established. However, after considering the effect of proviso, you can see that HRA and conveyance allowances, which were hitherto not included in computation of wage, have now been included, and the wage of Mr. X after considering the second proviso is rupees 9,850, which is marginally higher than that of Miss Y, and hence gender equality is established. Now we'll look into the computation of wages for the purpose of calculation of bonus. Presently, bonus is to be paid as a percentage of wage calculated in terms of the Payment of Bonus Act. However, since Bonus Act is now being subsumed under the wage code, bonus will have to be paid as a percentage of wage calculated under the wage code. This is likely to increase the bonus for employees who either have other components of salaries, which although not included in definition of wage under the wage code, but have now been included in the definition under the code, like HRA, medical allowance, special allowance, etc. Now let us look at the example. Mr. X is getting CTC of rupees 10,000. However, his wage in terms of the definition of Payment of Bonus Act is only rupees 5,500, and he was supposed to get bonus as a percentage of rupees 5,500 only. However, since medical allowance, special allowance and other items which were excluded under the Payment of Bonus Act have now been included in the wage code, his wage increases to rupees 7,250 and hence Mr. X will be eligible to get a bonus as a percentage of rupees 7,250. A point to be noted here is that, as discussed by my colleague Zahir earlier, every employee drawing wages up to an amount to be notified by appropriate government shall be required to be paid bonus. Here, in case the actual bonus of an employee exceeds the amount so notified, bonus shall be payable considering the wage of the employee to be higher of the amount so notified or the amount of minimum wage. So in the above example, we just discussed that bonus is payable as a percentage of rupees 7,250. However, say the amount so notified by government is rupees 5,000 and the rate of minimum wage notified is rupees 6,000. In this case, bonus will have to be calculated as a percentage of 6,000 being higher of the amount of notified by the government and the amount of minimum wage fixed and not rupees 7,250. This reduces the burden of the employer. Now, since amount of bonus to be paid on wages computed depends upon the amount of allocable surplus, let's have a look at the meaning of the term allocable surplus under the existing law as well as under the code. As can be seen, while in the existing scenario, allocable surplus is 67% of the available surplus in case of company which is not a banking company, and in case of a company which has not made arrangements for declaration and payment of dividend, it is 60% in other cases. In the proposed scenario, against the 67% which was
there earlier, I think now it changes to
60% in case of a banking company and 67% in case of other companies, even the companies which have declared and paid dividend.
So which means that from the point of view of, for our clients and all the people present on the webinar, we do need to keep this in mind, right? Because the definition of allocable surplus is changing, and therefore from 60%,
it is now increasing to 67%, and hence there is a possibility of increase in the bonus payout.
Correct. So that becomes very important. Thanks for pointing it out, sir.
Thank you. Having discussed the key changes, I hope it is clear that the employers are now possibly required to restructure the CTC of its employees in view of the difference in definition of wage under the existing laws vis-a-vis the one given under the code. However, the restructuring needs to be done very carefully because there are other implications as well. For example, the Provident Fund and Miscellaneous Provisions Act provides that Provident Fund is to be contributed as a percentage of the basic pay, the DNS allowance and retaining allowance, which now includes other allowances as well in view of the Supreme Court ruling. Thus, in case these allowances are increased in order to fit into the scheme of minimum wages, there is a possibility that the PF outgo will increase. Similarly, in case of ESI is to be contributed as a percentage of the wages defined under the ESI Act, which is different from the same defined under the code, and there is a likelihood that ESI outgo may also increase.
Is there a chance that we see that these, once the other labor codes come in, that there will be some amount of rationalization done so that the issues that you're talking about are taken care of? Or do you think there is a way in which this can be reworked so that while the wages need to be restructured, the PF or the ESI outgo do not go out? Is there a possibility of being able to do something?
No, it is expected that once these laws are subsumed in the Code on Social Security, the definition of wage will be aligned to the one given in the wage code. And there is a likelihood that this differential treatment will go away and a standard definition of wage will be followed, on which the amount of PF contribution and ESI will have to be paid.
But from all likelihood, those numbers, once the wages are restructured to increase the amounts of basic and dearness allowance,
are likely to increase.
The implications are that it is likely to increase.
Correct. Okay. I'll now hand over to Vaishali, who will take the discussion forward on inspection and penalties under the code.
Thank you, Saurav. So I will be covering the last two bits of our presentation. Thank you to my colleagues who have explained the important aspects of the code. And as you can see, inspection and penalty both are the pain points of an employer. The arbitrariness, the ad hocness of the inspection that is there in the existing scenario is always a worry to prepare before an inspection. I think most of the employers who are there in this session can completely relate to the problem areas. So I will not be explaining how the process of inspection is, because we are all aware of how it happens. It is majorly a point where an inspector comes, an inspection happens, examination of the documents and records happen, and it is a seizure of the documents and records. But where the problem lies is the arbitrariness, which is my first point here, because the inspector in the existing system has always been appointed through a local limit by the appropriate government. So there is no shuffling between inspectors, and that creates a nexus between the employer and the inspector that doesn't help meet the compliance regime, meet the requirement properly. So it is very important that this arbitrariness and malpractice in inspection is eliminated, and the jurisdiction of inspector gets shuffled. This will help bring in more transparency, and of course the web-based inspection scheme that I'll be talking about in my coming slide, and its importance.
Well, my colleague Vaishali has definitely talked about an important pain point. Just to clarify, that we are not for a moment suggesting that there is a lot of nexus and nepotism that is going on currently. It's just that when we go out and do our compliance-related audits in different businesses, factories, hospitals, so on and so forth, we do see the frustration that comes out from the team which deals with labor inspectors in terms of more than just malpractice, in terms of the ad hocness or the uncertainty around the way the inspection will be done, or the kind of documents that will be required to be presented, which is probably what has led to the current regime or the wage code coming in, where the term inspector in itself is going away and is being replaced with inspector come facilitator. Sorry,
Yes.
Vaishali, for
Absolutely, Indranil. I completely agree with you, because it is definitely a stressful procedure that an employer needs to go through to prepare all the documents to meet the requirement of the inspectors and ensure that they are not under the radar. So I'll just quickly take you through the central inspection scheme under the Business Reform Action Plan, which, if most of you who would have joined in the earlier session of our webinar, that is a roundup of regulatory updates, we spoke about recommendation 65 and 66, which we observed that the government recognized and intended to eliminate the inspection happening in silos, and wanted to plan the inspections by the inspectors so that the visits were more coordinated, so that the employers were not so stressed in preparing, and so that there is a proper transparency in the inspection process. Moreover, the process that led was a physical process. So if it is made online, that is as per the recommendation of the BRAP 2019, the procedure becomes more easier. The documentation, the record keeping becomes a lot easier. So there is a set. So when you're going for an audit, so usually we try, like when Lexplosion does an audit, we try to first send you a list of items that we would like to see. So if that process is online for an inspection, it's very important for the inspectors to share what they want from the employers, instead of going to the department, going to the offices and asking for it. So this streamlines the process. I think that is what the BRAP plan intends to bring. And surprisingly, the wage code tries to implement all of this while it is still awaiting to be enforced. It comes up with the first thing that Indranil pointed out is inspector come facilitator. Inspection is not a worry. Inspection should be guidance based. That is what we understand that the wage code wants to do. And there is an inspection scheme that they are referring to under the wage code, which we are hopeful is going to come out soon, with the code also coming into force, because those would be the guide points through which the inspectors can be retrained. The inspectors can be made sensitive about how they should react to non-compliances and how they should inform the non-compliances and advise them. A web-based process of inspection where the information can be sought for electronically, and most importantly, random selection of inspection. So The wage code aims at one thing that we observed through the reading of the code was they do not want to choose inspection as per local limits. They want to choose inspector cum facilitators irrespective of the geographical limits. This would not create a constant nexus that, as Indranil was saying. So, most important objective of the code under the scheme of inspection is my first point in the slide, advice, which was missing in the existing system. So we need to understand, we need to be sensitive. So it's very important for the inspectors, and it's very important that the relationship between the inspector and the employer at the time of inspection should not be of panic. It should be to be aware of how can I change the process and how can I be compliant and how can I ensure that I am following the processes of law. So that is the first step that the wage code proposes to implement, that is advice. I'm sure the scheme is going to provide a detailed explanation on the process. Moreover, inspect, examine, seize is all of that is happening in the existing process. So the same process will be followed. The only difference is there will be a facilitator as well. So the inspector come facilitator, the point is very important to note. Don't be scared of an inspector anymore, at least. Let's try to be compliant by understanding what they are trying to say.
As a matter of fact, by making sure that it's randomized,
Yes.
it's not the same inspector, the inevitable worry of one person in a particular jurisdiction constantly threatening you with action goes away.
Yes.
That fear goes away.
Yes, absolutely.
With the web-based section of the inspection, what happens inevitably is that there is this initial period that you get when you get to see what documents are required,
Yes.
prepare yourself, upload them electronically before the actual process of inspection starts. So that whole thing is very, very important.
Yes, absolutely. And also, just to point out here is, you must have received an update from us where we recently shared that EPFO is clipping the wings of the field officers. So something that I wanted to point out here, because with the wage code coming in its way, we are seeing how the government is becoming aware and how they are taking steps. So EPFO is taking that step where the field officers were referring to a judgment on the coverage of the basic wage. They wanted to examine if the compliance was being met. But then the head office is saying that no, we cannot do that unless we have evidence, unless we have proof, we shouldn't go and start inspecting. So the larger objective of the code, as I'm saying, and I would like to repeat and continue, is advice, of course, but to rectify. So under the code, inspectors are going to allow employers to rectify the errors of non-compliances and also help you comply with the code. So the advice and rectify goes hand in hand, but mind you, the rectification should not bring a smile on your face unless you know the conditions. So there are a few conditions. You get a chance to rectify only if you're doing this rectification within a specified time that the inspector is giving you. Mind you, if the violation of same nature is repeated within a period of 5 years, you will be prosecuted. So while the code is giving you the chance to rectify, it is also alerting you that you have to be careful and you should not take it lightly that no, I will rectify and things will be fine. But no, they are telling you, so let's work together to be compliant. So moving on to the next part of my discussion is the penalty, which is connected with what I just spoke now on the rectification. So revised penalties in the under the code here. So existing processes that got subsumed, especially the laws that got subsumed under the code, had penalties which, if you observe, was imprisonment in the first instance. But the code is grading that, and code is actually simplifying the penalties here and also allowing employers with a chance to first get a penalty of fine. So the first offense, so if you are not paying wages less than the amount due, then the first instance penalty is a fine of 50,000. Now there is a time gap. So the time gap is within 5 years from the date of first offense. If you're committing the second offense, then comes your penalty of 3 months and a fine of 1 lakh or both. So in the first offense itself, the fine is imposed. So if you see going on with the next penalty.
So I think the point to make here, Vaishali, is that you start with an opportunity to rectify.
Yes.
So there is a cure period that is being provided. If you cure and you carry on the right way, then there is no worry about any further penalties.
Yes.
If you cannot rectify, then the second stage of so therefore the graded penalty concept that they're talking about. Then comes the penalty of fine, which then gives you another opportunity to correct without having the fear of imprisonment.
Absolutely.
So from having serious imprisonment related consequences which added to the discretion of the inspectors,
Yes.
because there was an opportunity to either fine or imprison or do both, and many inspectors use that imprisonment as a threat to get additional benefits.
Absolutely.
That will not be possible anymore, because they will have to first be given an opportunity for rectification, then penalty, and then only imprisonment. So that to that extent, the fear of inspection and the fear of penal consequences out of labor-related compliances significantly reduces with this change.
Absolutely. And to add on to what Indranil is saying here is, there is a clause in the wage code where they are actually saying that the code provides for appointment of officers not below the rank of under secretary to the government or an officer of an equivalent rank to dispose of cases punishable only with fine up to 50,000. So if you see the penalties here on the screen, all of this are the penalties which are up to 50,000, and less than 50,000 is the first offense is fine. So this I think is going to help reduce the litigations. You don't have to depend on the subordinate jurisdiction judiciary so much, and this should be resolved by the highest rank, that is the Under Secretary to the Government of India, or an officer equivalent of that rank, to help reduce the burden of the courts and help reduce the stress of litigations.
And by making sure that it's at the minimum an Under Secretary,
yes.
What again the government is doing is making sure that there is a certain level of seniority within the bureaucracy
Yes.
who gets to deal with these matters, and not everybody.
Absolutely.
So that will ensure that the matters are dealt with fairly, and also by making sure that the amount is 50,000, at least all offences in the first instance get covered.
Yes.
Because there is no offence that we have been able to identify under the wage code as of now, which is where in the first instance the penalty is greater than 50,000. By doing that, we will, as you rightly pointed out, probably see a significant lessening of the burden of the lower courts in dealing with labour matters,
Yes.
and therefore hopefully the resolution will also happen faster.
Yes.
So that's the expectation, of course, and it's still early days.
Exactly. So now the last segment, and as Zahir said, saving the best for the last. This is going to bring a big smile on the faces of employers, because the code now is soon going to allow employer to complain against an actual offender. So just to simplify, as you can see here, employer is charged of an offense under this code. Employer, if has the proper steps, the due diligence, if the employer has taken all of that and can prove to the court that there is an actual offender who has done this offense and can prove that person to be guilty, then the punishment of the employer will be discharged. Now, just a situation. So in today's business, Indian business, we usually do not work in silos. Like, we do not have only our own employees, right? We do have contract laborers where we do engage a lot of contractors to provide us labor. So, we ensure, as a principal employer, we definitely ensure that through our representatives, payments are done on time, payments of minimum wages are done. But, somewhere there happens to be a gap, and some foul play happens, which ends up, getting a stress for the principal employer as well, because there is a level to which the principal employer can be responsible as well. And a very important aspect to what in the beginning what Zahir was covering, and the part that Madhura was covering on the burden of proof as well. It is important that the contractors who are covered as an employer now be aware and be careful. All the burden cannot shift to the principal employer. So the principal employer gets that right here, will soon be, rather, let me clarify, till it is getting effective, the wage code. After the effectiveness, the employers will get the right to complain against the actual offender. Make sure that employer is proving that the due diligence is conducted, that the employer is not aware of this situation, and then prove to the court that the actual offender has committed the offense, will release them and discharge them from the punishment that they have been charged with.
This is in a way a safe harbor
Yes,
provided
absolutely.
to the employer, in the sense that if there is a contractor like Vaishali was mentioning who is actually fudged records tried to establish that they've been paying minimum wages, and despite the employer having done appropriate due diligence, that has not come out clearly. The principal employer in that particular case will be able to go, and if they can establish that they had taken all the right steps, they can pass on the responsibility to the person who's actually committed the offense, which in this particular example would be the contractor. And like we've discussed earlier, contractor is now specifically defined as a part of the definition of employer, which would mean that that burden of responsibility can be shifted from the employer, the principal employer, to the contractor as well.
Yes.
An interesting point, again, once the rules come out, once the notification of the sections happen, it will become even more clearer as to how this whole thing will pan out. I think with this, our session for the day ends. We are already significantly behind schedule, and we do appreciate that all of you have stayed on beyond the time limits prescribed by us, which was 5 o'clock. But we do have a number of questions, and we will try and take a few of them now, and probably we will stop in about 5 to 6 minutes with whatever responses we can give in that time. And after that, we will take on the rest of the questions offline. And our apologies for doing that, but I think more than half an hour beyond schedule is unfair even by Indian standards. So we will start with a question from Sangamitra Sawant, which was about overtime. So the question was, what about overtime? Is there a limit on overtime? So we interpret the question to mean, is there an upper limit on the amount that can be paid? Which is, can it be instead of 2 times, can it be 4 times or 6 times? The answer is no. It can be whatever is the limit set. It cannot be lower than 2 times. If your question is with regard to the amount of overtime that can be paid in terms of the number of hours of overtime, overtime is primarily discussed as a part of shops and establishment tax of different states. There are numbers of hours which are prescribed in terms of the maximum number of overtime that can be done. That will remain unless it changes subsequently. So for the moment, that is not going to change. So that portion remains as is. The minimum floor for overtime is now being set at 2 times, and that's really the main difference that is happening for the moment. There is a question from Chandrasekhar and Rajendran on when do we get the notification of bonus salary threshold limit, which is bearing on outflow. The notifications we are absolutely not sure about when the notifications will come. At the moment, the wage code has received presidential assent. What the code says is that the notifications will come in due time, and different parts of the code can be notified at different points. So to give a specific date is difficult at this moment, Mr. Rajendran. We are hopeful that it will happen eventually, and we will keep you posted. If you're already using Comrisk, or if you're a part of our client base, you will definitely be amongst the first to know once the notifications come. The next question is from Purvi Mathur. So national minimum wages is for both employee and worker or not? Like we discussed briefly, and I'll just quickly summarize what we talked about. It seems that the minimum wages section of the wage code is only applicable to workers and not employees. But like we also mentioned at the beginning of the discussion on minimum wages, there is a mention of employee. And therefore, it is not 100% clear. But from the overall discussion that is there on minimum wages in the wage code, it does look like it will apply only to workers and not employees, which will mean that people in managerial or administrative roles or people in supervisory roles earning more than 15,000 rupees will not get impacted by the minimum wages. The next question, and we do not have the name here, is once the code takes effect, do we need to make payments electronically only? The answer is no. You can continue to make payments by other means, including by check or by cash. Only with regard to payment of bonus, that payment needs to be made only and exclusively, at least from the reading of the wage code as of now, by means of electronic means. We also have a question from Bharat Ambike. Any penalties mentioned in full and final settlement not done in 2 days? 2 days means post leaving right. So yes, the second question first. 2 days from the date of release. So 2 working days rather from the date of release is what is prescribed. The penalties related to specific sections have still not been clarified. So if we look at it from the point of view of the residual or the general penalty, the minimum penalty is prescribed as 20,000 rupees. But again, we will have to wait for the court to come up to be absolutely sure about what that would be. There's another question from Chandrasekhar and Rajendran on can you throw some light on same experience? Is it new? How do we ensure that experience is same or similar? Yes, the concept of experience is new part of the equal remuneration portion. Like we discussed when we talked about this portion, this does leave some element of ambiguity because experience is not clearly defined. We might see a specific definition of experience with the notifications or with the rules, but without that, I guess one will have to go with the logical view of experience and interpret it as a prudent person would do, which is typically the test that is applied in law. So I would assume that that's the test that will have to be followed. Then there's again a question from Sangamitra Sawant on does this code deal with unionized employees? Yes, there is a concept of worker defined, which is in sync with the present Industrial Disputes Act. The code also defines industrial dispute, which connotes that the code will deal with unionized employees. There is one more question we'll take for the moment, and I know that there are other questions which are coming up. Our apologies for not being able to take them online, but we will definitely respond to you after the session. The last question, and my colleague Saurav Chaudhary will take this up with regard to the code. Does the code also talk about distribution of bonus from profits? Saurav, over to you. And with that, we'll end the question answer session.
The law regarding distribution of bonus out of profits or out of losses remain the same as it was earlier. This specifically says that the minimum bonus of 8.13% will have to be paid, or rupees 100, whichever is higher, whether or not the employer has any allocable surplus during the previous year, which essentially means that even in case of loss, bonus will have to be paid.
And of course, with regard to allocable surplus, we've already had that discussion. So with this, thank you, ladies and gentlemen. We really appreciate you sparing the time, especially since we had to start late because of some technical issues, as we mentioned. We really appreciate your time today. We really appreciate the questions that you asked and your patience for staying with us. We will remain available for any further questions and answer any doubts that you might have. We will all eagerly wait for the wage code to be passed and or rather to be notified so that we can all see the benefits coming out of it. We're also waiting for the other 3 codes to get presidential assent, which should hopefully happen in the coming few sessions of Parliament. And with that, we'll have more aspects of labor law being codified and rationalized. We will wait for that to happen. Thank you once again. Have a fantastic weekend, and we hope to see you again soon. Thank you very much.